Welcome to the Protecting Students' Privacy Training. This training will cover important information as it relates to the Family Educational Rights and Privacy Act. If you have any additional questions or concerns after completing this training, please contact the Office of the Registrar located in Jernigan 101. Since becoming an employee in education, you may have heard the acronym FERPA used many times. The Family Educational Rights and Privacy Act, also known as FERPA, is a law that protects the privacy of a student's educational record. This law applies to any school that receives funding under any applicable programs of the U.S. Department of Education. Obviously, then, this law applies to Queens students as well. FERPA also grants parents and guardians certain rights in respect to their children's educational records. However, once their child reaches the age of 18 or attends school beyond high school, these rights transfer to the student. This does not mean that parents are no longer privy to any of their child's information. However, it does require that the student sign a form that authorizes the release of specific information to either the parent or any listed designee. Consequences of non-compliance can be detrimental to the overall operation of the institution. Non-compliance can result in monetary fines, removal of federal funding, and can also potentially open the door for lawsuits and other penalties. FERPA compliance is an integral part of promoting a safe, secure, and private educational experience for all students. Failing to abide by this law can cause a ripple effect across campus and impact the entire university's reputation. Therefore, it is critical that all Queens faculty and staff, or any parties involved in the protection or dissemination of personally identifiable student information, are aware and understand the rules regarding handling student information. Let's take a moment to review the students' rights. Students have the right to take the following actions. They can halt the release of personally identifiable information. All students have the right to deny release of any of their personal identifiable information, which includes things such as name, address, student ID number, social security number, telephone number, and email addresses. Students have the right to obtain a copy of the institution's policy concerning access to their educational records. If a student approaches you as it relates to our policy, please refer the student to the Office of the Registrar, who can provide them with a copy of our institution's policy. They may also inspect and review their own educational records that we maintain here at Queens. Schools are not required to provide copies of these records, and students must view records on-site and in person unless it is impossible for them to do so. For example, they live too far away from the campus. They can also request that a school correct records that they believe to be inaccurate or misleading. If the school decides not to amend the record, the student then has the right to a formal hearing. After the hearing, if the school still decides not to amend the record, the student does have the right to place a statement within the record setting forth their view about the contested information. Queens University of Charlotte requires written consent for the release of any student's educational records. The Office of the Registrar serves as custodian of student records. The FERPA authorization of release form should be obtained from and submitted to the Registrar's office. It is very important to note that the FERPA release form must be completed in its entirety and it must be signed by the student. The student must then list the specific information to be released and the duration of access to the records. These include things such as transcript, admission, records, grades, and disciplinary information. Here's an example of the student consent for access to educational records form. In Section A, the student will list out the specific information to be released, such as their GPA, student ID number, or academic progress. In Section B, the student should indicate the person or people they want to have access to their records, and the contact information for that person should go in the second box. In Section C, the student can indicate how long the release is good for. One-time use means you will not provide any information beyond this single incident. Limited use allows the student to specify exactly when the form should expire, and long-time use allows the form to be in effect indefinitely or until the student provides a written withdrawal of this form. Section D, the student should indicate why they are releasing this information to the indicated person. If the top three purposes are insufficient reasons, they should check other and specify why this information is released in the blank space. Lastly, and most importantly, they need to sign and date the form. The form will not be accepted without the signature of the student. Faculty and staff are considered school officials that may already be privy to either class rosters or other basic student information. However, faculty and staff may not access other student academic records without demonstrating legitimate educational interest. If any member of Queen's faculty or staff would like additional information about any student records, they must contact the registrar's office to access full disclosure. There must be a signed release of information form on file by the student. The form must specifically list what information may be released to the school official. So, who can be deemed as a school official? Any member of Queen's who acts on behalf of the student's educational interests within the limitations of their need to know. These members include administration, faculty, staff, and other persons who manage students' educational records. Students serving on official committees and or assisting another school official may also be considered as a school official. However, a further consent release is always required if additional information desired exceeds the limitations. So, who is considered a Queen's University school official? Someone performing a task specified in his or her position or contract, the student's education, or is related to the discipline of a student. Someone who was providing a service or a benefit relating to the student or student's family, such as healthcare counseling, job placement, or financial aid. And lastly, someone who maintains the safety and security of the campus. It is important to understand the difference between directory information and a student's educational record. Queen's designates the following information as directory information: a student's name, local or permanent addresses, email address, telephone number, class, major field of study, dates of attendance, enrollment status, degrees, honors, and awards received, participation in officially recognized activities, organizations, and sports, height and weight of student athletes, photographic, video, and electronic images of students taken and maintained by Queen's. Queen's reserves the rights to disclose any of the above information without written consent. Students have the right to restrict their directory information, but they must do so by completing the non-disclosure of directory information form. This form is available in the Office of the Registrar in Jernigan 101. On the next slide, we will show you an example of this form. Here is a sample of the non-disclosure of directory information form. Students can obtain this form by visiting the Office of the Registrar. They must sign and print their name in order for this form to be effective. There are times when Queen's University of Charlotte may disclose educational records without consent of the student. Those times are as follows: to university officials who have legitimate educational interest, to authorized representatives of federal, state, or local educational authorities. Other times that we may disclose educational records without consent are continued on this slide. In connection with a health or safety emergency, when the information is designated as directory information to the student, to a victim of an alleged perpetrator of a crime of violence or non-forcible sex offense, in connection with a disciplinary proceeding at the university, to a parent of a student under the age of 21 concerning the student's violation of any law or policy regarding the use or possession of alcohol or controlled substances. If this disclosure concerns sex offenders and other individuals required to register under state and federal law. Now we will review some scenarios to apply what we've learned today. As I read the scenario, think of how you should respond based on today's training. I will then read and display the appropriate response. There will be 3 scenarios for you to carefully consider in total. A faculty member requests a student's transcript in an effort to review the student's academic progress before providing a letter of recommendation. The faculty member states that the student has already been made aware of the request, but there is not a signed release form on file. Take a few seconds to think of how you might respond to that member. You should advise the faculty member that the student must provide a signed release of information form to the Office of the Registrar prior to approving the release of specific information to the requesting faculty member. Great job. Let's move on to the next scenario. Parents contact a faculty member requesting information on their child's academic performance, such as are they attending class and what are their most recent grades. The parents insist on having this information as soon as possible because the tuition is paid by them out of pocket and they fear their child is not doing well academically. Take a few seconds to think about how you would respond to these parents. You should inform them that all students must complete a release of information form that lists both parents' name. They must also list the specific information to be released to the parents and the duration of time that the parents are privy to this information. Great job. This is our final scenario. Brooke misses class on a day that a graded exam is expected to be returned. Brooke is anxious to know her grade and gives Stacy, a fellow classmate, verbal permission to pick up her graded exam. The professor knows Brooke and Stacy are good friends because he always sees them chatting and they sit together. Is it okay for the graded exam to be released without a signed authorization for release consent form? Take a second and think about that. The answer is no. Brooke must provide the professor with a signed consent form listing her as the authorized recipient and specific information to be released to her friend, for example, the exam grade. This concludes your FERPA training for today. We hope that this information has been helpful and clarifies how FERPA impacts your role here at Queens. We also know that this is a lot of information, so it's important to remember one thing. When in doubt, don't give it out. And then you can reach out to the registrar's office for clarification. Thank you for participating in this training and have a great day.